submissions and also look at what has been filed on this list, which we had not had opportunity to look at law, two preliminary points of law, where we requested you, invited you to submit to the court, and that is whether the applicant has locus standi to bring the issues at hand before this court, and whether the Supreme Court has the jurisdiction to hear the matter. We had earlier on studied the submissions of the applicant, and during our recess we had the opportunity to study what was filed on ECMIS by the respondents. We also considered the oral submissions in court by the respondents, as well as the oral submissions or reply by the applicant in court. The court has arrived at a unanimous decision, and I invite my learned brother, Justice Isama Madrama, to deliver the decision of the court. But a more detailed ruling will be uploaded on ECMIS later. So, my Lord, Madrama.
Thank you, my Lord. This is the short ruling of the court. We have considered the oral and written submissions of the parties and the pleadings. The question that we sought the parties to answer is whether the applicant has locus standi to invoke the original jurisdiction of the Supreme Court, and whether the Supreme Court has jurisdiction to hear and determine the application. This was stated in questions: does the petitioner have the right to appear? 2, does the court have the power to hear the pre-election dispute? 3, does the court have the power to grant a prohibitory injunction against the carrying out of a constitutional process? On locus standi, Article 104 of the Constitution is narrowly construed. It provides for a petition by an aggrieved party who must have been a competitor or candidate. It has to be a post-election matter after a declaration of results. The orders that an aggrieved party may petition for are statutory. The word aggrieved party is exclusively construed. Post-election matters are time-bound. Orders to be made are statutory, such as nullification of elections after they are heard in a time-bound petition, declaration of a winner, or ordering re-election. The applicant does not qualify to be an amicus curiae of this court, as he has not been admitted and there is no pending matter before the court. The applicant's application for leave to be a friend of court is improperly before the court, as it doubles as a party. The applicant should be a neutral party. Further, this court is restricted under Article 104 of the Constitution to make orders that are statutory. Coming to the subject matter jurisdiction, does the court have the power to hear pre-election disputes? The Constitution, Article 132 of the Constitution, establishes the court primarily as an appellate court, the final arbiter of appeals from the Court of Appeal. The primary role of the Supreme Court under Article 132, Clause 2 and Clause 3 is to hear appeals. It follows that the exercise of original jurisdiction is an exception. The only original jurisdiction the Supreme Court possesses is that conferred by Article 104 regarding presidential elections. This has created a rigid jurisdictional binary. If a matter is a presidential election petition filed by a candidate, the Supreme Court has original jurisdiction and final jurisdiction in the matter. If the matter is anything else, including a pre-election dispute filed by a voter, the Supreme Court can only hear it in the exercise of any prescribed appellate jurisdiction, if any. The applicant's application is not a pre-election matter, and the Supreme Court enjoys appellate jurisdiction. The applicant's matter is a pre-election matter. Sorry for that. And the Supreme Court enjoys appellate jurisdiction under Article 132 and cannot sit in an original matter for matters that do not fall under Article 104 and Section 61 of the Presidential Elections Act. The scope of the Electoral Commission mandate includes handling complaints regarding nominations, academic qualifications, campaign irregularities, and voter register issues. A person, including a non-candidate stroke voter, aggrieved by pre-polling irregularity can file a complaint with the Electoral Commission. If a party is dissatisfied with the Electoral Commission's decision, the pre-polling complaint, the recourse is not to the Supreme Court. Under Section 15, subsection 2 of the Electoral Commission Act, a decision of the Commission may be appealed to the High Court. To injunct a constitutional process where the specific relief sought, an injunction to bar the holding of election, places the petition squarely in the specific relief sought, an injunction to bar the holding of election, places the petition squarely in the pre-election phase. There is, however, a constitutional command to hold elections under Article 62, Clause 2 of the Constitution. Article 61, Clause 2 of the Constitution. Article 61, Clause 2 of the Constitution commands the Electoral Commission to hold presidential elections within the first 30 days of the last 122 days before the expiry of the term. This is a mandatory constitutional duty. It follows that a court cannot order barring the election. It follows that a court order barring the election would essentially order the Electoral Commission to violate Article 61, Clause 2. Courts generally have no jurisdiction to issue injunctions that compel the violation of the Constitution. The third respondent is a sitting president of the Republic of Uganda who enjoys presidential immunity in office under the Constitution. In the premises, he is improperly sued. Orders. We strike out the proceedings against the third respondent. The applicant's application is dismissed.
Staying the elections, 2026 general elections, simply because the Supreme Court had already given orders 10 years ago to make reforms in the electoral laws and the other procedures. The court never did that. I mean, the government never adhered. They went ahead and organized the 2021 election. In the other ruling of Mama Mbabazi versus Attorney General, versus the Electoral and the Electoral Commission, the court gave 10 orders. And the court said they must be enforced within 2 years. So the latest would have been 2018. They never did that. As a result, they organized the 2021 election without the amendments or the reforms. And now they are organizing another one. So I saw that was a very grave mistake and an impediment to democracy. I ran to this court just recently and I prayed that it stayed the elections. And that is roughly until the government introduces, enacts and enforces, implements the reforms
Okay. If we take up the orders you are talking about, one would like to know what are those orders that the Constitutional Court ordered the Electoral Commission to do?
The most notable one was to remove the public servants from politics, elective politics. In fact, I can't go into details because
you can just outline them.
Yes, all people who are getting salaries from the public fund, the consolidated fund for that matter, or the money appropriated by Parliament and referred to as public servants. But in the Constitution, there is a provision they put there. Some people were excluded from that category, and those are the ones coming and hide under that. Under the reforms ordered by the court, that particular provision would have been deleted from the Constitution in order to operationalize that thing. No public servant is allowed. Here you can see ministers driving government cars, people like running for the president running for presidency, using public things, public vehicles, public what? It's like we are in an animal farm. We are no longer in the democracy. Everybody is doing. The other order was to introduce technology early enough. Actually, it said 3 years before the election, the laws concerning electoral technology must have been enacted and people educated. Here is a situation where we are bringing now laws by the minister, statutory instrument, instead of being a law, and so many other things.
Similizo okulonda kwa 15 January ngera agamba kooti nti alina ebintu bingi ebitamusanyusiza ekisingira ddala kuba nti waliwo ebintu kooti byeyalambika byeyawaako ensala mu 2016 ebadde tebinabakolebwa. Tuze mu kooti netubategeeza netuwoza mu kooti nti no kooti teyinza kukola kintu ekyo kubanga obuyinza tebulina obutuula mu musango nga omukulu ogwe abadde aleese. Era kooti nekkiriziganya naffe nti tebalina buyinza butuula mu nsonga eyo. Bw'aba alina ensonga yonna ekwatagana n'ebyokulonda bitwale mu Electoral Commission, agende mu High Court oba anaakomawo wano in form of an appeal bw'aba nga ajulidde singa omusango gubeera nga ensala temusanyusiza mu kooti ezaawo. Yali emugulumya ebintu yagamba mune ebintu kooti byeyawaako endowooza mu 2016 tebyatuukirizibwa. Naye tumugamba nti ekyo si kituufu kuba ebyo byonna kooti byeyayogerako byakolebwa era Attorney General